Thank you very much for tuning into this parliamentary submission in relation to inquiry into occupiers' liability in rental property related matters. Just a little bit about myself. My name is Samuel Douglas. I'm the lead advocate representing the Queensland Tenancy Union, and I look forward to taking you through this parliamentary submission. So who are we? The Queensland Tenancy Union basically provides tenants an information and advisory service to all Queensland tenants, and the union primary focus is concerned with ensuring the rights and responsibilities of tenants are protected under the local tenancy laws. The focus of this submission is on tenants who injure themselves at any point during their tenancy agreement and assess whether the current compensation system is effective in compensating these tenants. The submission will further explore obligations of landlords to establish whether the system is fair. Lastly, the submission will look at recommendations, particularly looking at potentially adopting a no-fault system, and also recommendation for reform, in particularly the onus of proof being on the appellant to justify liability, which has been a problematic area. Now for a little bit of a background into occupiers' liability in relation to property-related injuries. Traditionally, for most Australians, attaining a home has been really the number one goal of one's life. However, the increase in house prices relative to household income has seen a steady decline in home ownership rates. So you can see here I have listed household ownership versus renting demographics. So you'll see that more than 1/3 of Australians are now renting, with the proportion of low income households renting privately increasing from 16% in 1995 to 27% in 2018. This, amongst other economic factors, has caused adverse movements and record low rental vacancy rates. So you can see essentially it's soaring demand for rentals, which is what has been responsible for causing a rental or housing crisis. The number of tenants or increased tenants entering the rental properties sector has posed a potential risk actually for injuries in the event that a landlord has been negligent in keeping a property to the required standard. A study taken in 2019 and 2020 determined that more than 1/3 of Australian households reported, whilst they were moving home within the last 5 years, had structural problems in their rental properties. And a further 24% of renters have been unsatisfied with the current condition of their dwelling. As you can see here on this slide, I've got the top structural problems and satisfaction rates reported by tenants. So you can see here on the chart on the left, the most common structural defects that are in rental properties at the moment are major cracks in walls, rising damp, wood, rotten termite damage, and sinking and moving foundations, including major plumbing problems. So they're the major ones, and as you can see here also on this chart, there's quite a disproportionate increase on the amount of structural damage happening as a result of low income renters. So you can see the blue line is the non-low income, and the low income is the green. So proportionately, it's showing that tenants who are low income are suffering far more of a problem. And as you can see on the chart on the right, the satisfaction rates are so where I got that statistic about basically one in a quarter of tenants are unhappy with their current dwelling. You can see the statistics on the right here, including comparisons as well, not just renters but homeowners as well. The most common injury that's arisen from defective rental premises recently has been falls. And this chart on the left, which has been the top cause of home injuries and hospitalisation, this has been, this is a chart more generally, but happens to also be the same statistics for defective rental premises as well. You can see falls, this is disproportionately larger than every other type of potential injury that happens, for example, contact with objects. So falls are the most common cause of hospitalizations and deaths from injury in Australia, with approximately 100,000 people being admitted annually. Last year it was reported the cost of injuries such as falls and other pressure-related injuries had cost the Australian public health system an exorbitant $9.1 million for the whole year, $3.5 million of which was related to treatment costs. In Queensland, a study in 2007 showed that hospital-admitted patient services due to fall-related injuries among people aged 65 and over estimated to be costing the Queensland government $106 million a year. These estimates were forecast to double in 2015, given the population growth and increased fall-related emissions. The actual cost today is expected to be quite a lot larger, given the population back in 2007 for Queensland was 4.2 million and has now risen to 5.4 million. So you can see on the statistics in this table here, population growth in Queensland. So this table only goes back to 2011, but in the submission itself, I've got statistics for 2007. However, you can see here the 2022 rate was 5.24 million. Now we're going to move on to the law, which includes a summary, critique, and shortcomings. We're going to talk about duty of care. So duty of care is essentially the first element to establish an occupier's liability claim. So the duty of care at common law essentially means that a landlord has a duty to take reasonable care in avoiding foreseeable risk of injury to people having regard to circumstances of the case. This was stated in the Northern Sandblasting case, as per Justice Dawson at page 343 of the case. So, in addition to common law principles, the maintenance responsibilities of landlords in Queensland are prescribed in statute as well. For instance, in Section 106 of the Property Law Act 1974, and similarly in Section 185 of the Residential Tenancy and Rooming Accommodation Act 2008, Queensland. Section 9, subsection 1 of the Civil Liability Act 2003, Queensland, or commonly known as the CLA, prescribes a broader scope as to what precautions a person must take to not breach the general standard of care, which include foreseeability of risk, significance of risk, and considering the circumstances a reasonable person in that position would have taken. In assessing whether a landlord will be liable for injuries sustained by a tenant, a court will need to establish if the landlord breached their duty of care. In this case of Jones and Bartlett, the underlying principle was established that a landlord does not owe a duty of care where a risk of injury is not foreseeable and the object is not defective when it's used in its regular fashion, and the danger of that risk presented was not during an ordinary and reasonable human conduct. So, just a bit of background in this case. The tenant walked into a glass door and injured themselves. The house had been built in the late 1950s, at a time when the building and construction standards were different to today. But it was essentially built according to those standards. So essentially what happened is when this tenant injured themselves, the landlord was not aware of any issues with the glass sliding door, hence he couldn't have been foreseeable for him to know about the potential risks. And given that the sliding door was not used in its regular fashion, he couldn't have known. Once again, the landlord couldn't have known. Once again, it was defective. So it was for that reason that the tenant was unsuccessful with the claim. A similar situation happened in this case called Orderhire and Hicks. Essentially, a tenant injured themselves moving a fridge down a set of steps. So essentially, it would have been something like these gentlemen here in this picture doing with this fridge. The ordinary purpose of a step is for people to walk on, not to move a fridge. So the landlord had no reason to suspect that any warning that pulling a trolley onto a paver would cause a step to dislodge, and that was as per Justice Cooper's reasoning in that case, which ultimately led to the appellant being unsuccessful in their claim. Now moving on to breach and causation. So to establish causation as per the statutory regimes, if a landlord has breached their duty of care, it is necessary for the tenant to then prove a causal link as prescribed in section 11 of the CLA. So the tenant must establish the negligence of the landlord was a necessary condition of the occurrence of the tenant's harm, so it's a factual causation. And secondly, the scope of the landlord's liability extends to that particular harm, so that's the scope of the liability. At common law, causation is a test of whether the landlord's conduct in question played a role in bringing about that harm is the subject of the negligence claim. While the issue of causation is a question of fact to be decided by a jury or judge sitting as an arbiter of fact, the current legal test is that of common sense and experience. And that was said by Justice Dean in March v. Stramar in 1991, that case. The next issue will be to be discussed is the onus of proof, and this is subject to some difficulty, particularly for tenants, which I'll mention a little bit further, a little bit later. Sorry. So the onus of proof, the tenants always carry the onus of proof on proving essentially the balance of probabilities, any fact relevant to the issue of causation. This actually has a practical effect in that it can shift the onus of proof back onto the landlord once the tenant establishes the breach of duty or breach of care owed, and the occurrence of a foreseeable risk of injury. And a situation where this happened was in a case called Lloyd and Thornbury in 2019. I actually don't have it on this particular slide, but essentially what happened is a guy who was a tenant, he fell into a hole in the backyard of his house, and the landlord was aware of the issue in the sense he tried to put some poles and mesh around the hole, but essentially it was found out that the judge basically in that case said, look, you should have you knew that there was a reasonable risk that the tenant could fall into the hole. It should have been backfilled. So in that sense, the Court of Appeal actually found that the landlord was liable and breached his duty of care for the tenant. However, that was one of the more rarer cases, but generally the burden on the tenant to prove on the balance of probabilities of facts leading to causation are quite problematic. Firstly, it's quite unfair if an appellant can't prove more probable than not that the defendant was negligent, as this would render the appellant with no award for damages and left potentially with a lifelong injury, which occurred in the case of Hodson, which I'll go into some detail now. So in this case of Hodson and East Berkshire, essentially what happened is a child had fallen from a tree and suffered an injury or fracture. The hospital failed to diagnose his injury and sent the boy home. And the hip fracture resulted in a blood vessel damage, resulting in avascular necrosis. The trial judge originally awarded 25% damages for a 25% chance that the treatment would have made a difference. The hospital appealed the decision and then essentially found the judge was wrong to award any damages for the loss of chance, given that the rule is on the balance of probabilities, the injury was the sole cause. Now moving on to recommendations and to reform and adoption of a no-fault system. Recommendations to reform and a no-fault system. So, the QTU for the majority believes that the tort system surrounding occupier's liability is working satisfactorily. Tenants can, for the majority, rely on Queensland statutory regimes to ensure that landlords comply with their obligations for the more non-novel type issues or injuries. The exception is the obligations imposed on the appellant to prove, more likely than not, that the defendant is liable for negligence is in need of urgent reform. As you just saw in that case previously, it seemed pretty unfair for the child to get nothing. The QTU believes it's unjust for an appellant to be left in a vulnerable situation without the courts even considering the mere possibility that the defendant could be liable, at least in part. An appropriate measure to combat what happened in Hodson could be to introduce a no-fault system. The primary focus would be to put victims at the heart of the process and assist with rehabilitation, given the high cost of medical treatment. The adoption of a no-fault system would minimize the pressure on the public health system by allowing victims a partial sense of justice, rather than being forced to take an all or nothing approach to compensation. To conclude, this submission has discussed changes to the status quo in home ownership and the trend of people moving towards renting as a result of higher property prices and other economic factors. Also analysis on social and policy issues, including the cost to, say, the public health system and associated with occupier's liability. The laws around occupier's liability, its elements, and comparing them between common law and the statutory regimes. The shortcoming of causation, which was particularly around the onus of proof on the appellant to prove liability. And lastly, we looked at recommendations to reforming that issue of causation and adopting a no-fault system, which would, help these victims that potentially could be facing, the prospect of receiving no compensation at all, to help them with rehabilitation and get their lives back on track. On behalf of the Queensland Tenants Union, we really appreciate the opportunity to submit this parliamentary submission in relation to occupier's liability, and in particular with rental property related injuries of tenants. We sincerely hope that you take some of this information on board and hopefully there's some changes that come in by way of the reforms to better these victims in Queensland. So thank you very much.